Welcome to our training on referral pathways to the CARE Act process. So there are a few referral pathways specifically mentioned in CARE, including referrals from LPS designated facilities and court referrals. So this training is designed to help county behavioral health agencies, referring facilities, and courts understand the roles and expectations. The focus of this training is on those statutory referrals. However, we will also briefly discuss informal referrals from community partners and family members as well. So let's go ahead and look at our agenda for today's training. So we have a few different sections. In the first one, we're just going to provide some contextual information on the difference between referring and petitions, and then discuss those referral pathways defined by statute. Then we're going to focus in on facility referrals to CARE, and then focus on court referrals to CARE. And as I mentioned, we'll be focusing mostly on those statutory referrals, but we'll also provide some input related to community partner and other referrals. So let's take a look at our learning objectives today. The goal is that by the end of this session, you will have an increased ability to explain the difference between petitions and referrals, understand components of referrals for potential care respondents, identify differences in referral processes for various system and community partners, and also describe how counties may process and respond to care referrals. So today's training will be presented by two individuals from the Training and Technical Assistance team, Dr. Deborah Rose and Leela Kapoor. Dr. Rose is a licensed clinical psychologist with a history of designing and scaling new initiatives in behavioral health services. And Leela Kapoor has more than 30 years of public service as an attorney representing Los Angeles County and the City of Los Angeles, and has experience as counsel for the county department's health and mental health services. And in addition to this training, we also have an open forum where different individuals on the ground in counties talk about their referral pathways and how they're problem solving through challenges. So if you'd like to visit or view that panel, you can go ahead and view that session as well. And just to note that all of these training materials, including the links, are posted. So if you go back to the training resource page, you can click on those, the training material, and then click through. We also include the notes so you can follow along with the talking points, additional context, and those training and resources linked in the slides throughout. And now I'll turn to a live discussion held by Dr. Rose and Leela Kapoor to walk us through the referrals to CARE.
Thank you, Patricia. And Leela, I want to thank you for joining me today. I'm really excited by this presentation. Let's jump into this and talk about referrals to CARE. This is an image. Many of you have seen this before. It's an overview of the CARE process. I will not be going through this today. What I really want to do is focus on what's on the left side of the screen, the two hexagons that are orange, peach. And what's important to note here is that the civil process begins when a petition is filed. It can be filed either by the County Behavioral Health Agency or it can be filed by an outside petitioner. In either case, again, it begins with a petition. What we'll be talking about today are the instances or the possibilities of when one of those outside petitioner groups makes a referral to the County Behavioral Health Agency, essentially by saying, here's an individual that we want you to consider their eligibility and make a determination if the person could meet or may meet capacity. In that case, the County Behavioral Health Agency would file the petition. So I think we're going to move forward and then talk about referrals in detail. In order to ensure that we are all on the same page, and for this training, using the same language, we're going to distinguish between referral and petition. And we are intentionally using those terms to mean very different things. A referral is, again, when a person or an agency provides information to the County Behavioral Health Agency, and they're saying, we'd like you to consider filing a petition on this person. Again, the referral doesn't mean that a petition has been filed. It doesn't begin the process. What it does is it says to the County BH, we'd like you to look into and consider, does this individual meet eligibility criteria, and would they benefit from care? Will you please consider filing a petition on behalf of us or about this individual? The care process, the CARE Act, has some very specific statutory language about who can make these referrals and a little bit about what that referral pathway looks like. And of course, we're going to get into that in detail in a moment. At the same time, there's nothing that precludes county behavioral health agencies from accepting referrals from community partners or from families, for example. They may create pathways that allows them to accept these referrals and to still continue to consider the individual in that determination. And so we'll talk about this in a moment, what that might look like if counties do decide to go down the path of accepting referrals from community partners. A petition, as I just mentioned, is an actual filing with the court. So the process again begins when a person, an agency, files a petition for care consideration. We're also going to talk about that in a second. Important to note that any eligible petitioner could consider a referral to the county behavioral health agency, although not each one of those petitioners are specified as statutory referrals in the CARE Act. So as we continue, I would encourage you to think about what might be the benefits of considering a referral over a petition. We certainly think that it may offer opportunity to quickly assess the individual, to do early outreach and engagement. It's an opportunity to really think about what kind of services can quickly be developed as part of a care process. A referral over a petition may lead to better outcomes. Potentially, it may mean that a petition is more thorough or is filed with more accuracy with the court. So that would likely improve access to appropriate care. And then certainly it could be a streamlined process for the many stakeholders who are committed to this process. Let's go to the next slide. You've likely seen this slide before. These are eligible petitioners as defined by the CARE statute. I am not going to go through this list. What I am going to say is, again, that many of these individuals are also called out on the statute on referrals, and some of them can either file a petition or refer to County BH. A couple of examples may be an LPS facility who has someone on an involuntary hold could choose to petition or could choose to make the referral to County Behavioral Health. And we'll talk about some of those considerations. Leila will get into them in a moment. And again, if a county does decide to establish a pathway for others to make referrals, then individuals like family members, first responders, et cetera, might consider a referral instead of a petition. Next slide, please. The title of this slide is statutory referrals. And I do want to say that this is a term that we have created and are using because these are referrals that are specifically delineated in the statute. So to simplify the language, statutory referrals here are really when behavioral health agency is required to accept a referral from a partner or from a specific facility. They're governed again by the CARE statutes. And so what's written into those laws or their regulations give very specific policies and procedures for how those referrals can be made and how the county can respond to those referrals. Two categories, and we're going to get into these in detail today, are LPS designated facilities where someone is on an involuntary hold and specific courts. So again, we'll go through these one at a time, and we'll give you more information as we proceed. I'm going to turn to my partner, Leila, and now that I've talked a bit about some of the differences and similarities, Leila, I'm going to ask you to think about and to share maybe what would you consider to be the significant highlights and the difference between a petition and a referral.
Hi, Deborah. It's really great to be here with you again. As you've very well said, petitions are the document. It's a formal court document. It's filed in the court. It initiates the care process. Referrals are another pathway to get to that petition. A referral does not initiate the process. It's very important to remember that with a referral, you still need a petition to be filed. With most referrals, that's going to be the behavioral health agency filing the petition, both in for the statutory referrals and the non-statutory referral pathways that counties may create. So we're going to dig a little bit deeper now into statutory referrals, try to give you some understanding as to what the laws provide for, and to have some discussion around those areas in the laws that are not quite as clear and are going to be open to interpretation by the courts in the various counties. And then we're going to spend a little bit of time talking about the referral pathways that counties can create if they choose to, and what those might look like in those counties. So with that, I'm going to move right into the statutory referrals. And I'm going to start with facility referrals to care. As some of you may be aware, one of the statutory referrals, and this is the most recent that was added to the CARE Act within the last year or so, SB 42 added this referral pathway to the CARE Act. And so we do have a brief on SB 42. Would really encourage you to read it if you haven't had a chance already. But what this referral is the referral from an LPS designated facility. And we'll talk a little bit later on as to what is an LPS designated facility. And it allows the facility to make a referral for an individual who is on an involuntary hold. So it's important, two components: one, to be a designated facility, and two, the individual be on an involuntary hold at the time of the referral. Let's look a little bit at some of the specifics around these referrals. The timing. The statute encourages that the facility should make the referral as soon as clinically appropriate, usually during the discharge planning. So a lot of facilities are looking at this as a way to assist an individual who is either ready to come off of an involuntary hold, or perhaps they predict or project that he or she will be coming off of the hold soon, and they want to find a way to allow them to return to the community and with supports in place or pending, and get behavioral health involved at that point. Pursuant to the statute, the County Behavioral Health Agency has 14 business days to assess the individual once they've received the referral, and determine if they believe the individual either meets or is likely to meet the care criteria, the care eligibility criteria. And if they believe the individual may meet the criteria, they are to file the petition within those 14 days. Very important to note for the facilities that a referral to care does not allow the facility to hold an individual on an involuntary hold only for the purpose of allowing BH to complete its assessment. The individual has to continue to qualify for that hold for them to continue that hospitalization. And I would also note that a care referral does not affect the ability of the facility to also make an AOT referral. So this, again, is a new pathway that was developed. It is a referral that's provided for under the statute now, and again, would stress that it's a pathway you may want to consider, a facility may want to consider when they are in the process of or contemplating discharge of a patient who's been held in the facility for assessment and treatment. The next referral, if we can go to the next slide.
I think let's talk about the eligible facilities where these LPS referrals might come from.
I'm sorry. Thank you, Deborah. I got my screen got stuck for a second. I appreciate that. So eligible facilities in the definition is statutory. It's kind of a convoluted definition because it refers back to other statutes. But in essence, an eligible facility is a facility that has the ability to assess, evaluate, and do crisis intervention pursuant to Welfare and Institutions Code Section 5150, which allows for the facility to hold an individual involuntarily for an evaluation and treatment for up to 72 hours. A designated facility may also be a facility that is licensed or certified as a mental health treatment facility or a hospital by the State Department of Public Health, pursuant to WIC Section 5008, which may include a licensed psychiatric hospital, a licensed psychiatric health facility or a certified crisis stabilization unit. Again, a very technical definition. I think it was really meant to catch those facilities that have the authority and the ability to hold somebody involuntarily for purposes of evaluation and treatment. If you have any question as to whether your facility is a designated facility under this definition, consult with your legal counsel and they can help walk you through the statutory definition. I would reiterate that you need to keep in mind there's two components to this referral. One is the facility has to be designated, and the second is the individual has to be on an involuntary hold at the time of the referral. So let's move a little bit more, get a little bit more into the specifics around these referrals. Where is the referral made? The facility can make the referral to the county behavioral health agency either in the county where the individual resides, so their county of residency, or in the county where they're receiving involuntary treatment, so in essence, the county in which the facility is located. Who makes the referral? The referral has to be authorized by a licensed behavioral health professional employed or contracted by the facility. The licensed behavioral health professional is also defined in the statute, so if you have any questions, you should look at that definition. But again, the licensed behavioral health professional needs to have knowledge of the individual's case. They have to have been involved in the individual's treatment during their involuntary hold. And they have to have a belief that the individual meets or is likely to meet the criteria to qualify for the care process. The licensed behavioral health professional or their designee must sign the documentation, must sign the referral. So, and again, they're looking for a professional who has knowledge of the individual and the individual's treatment. Since we recorded this training, the state has put out the referral form that can be used for the referrals that we have been discussing over the last couple slides, as well as the behavioral health information notice that provides guidance on the use of the form, as well as some guidance on these types of referrals in general. A facility or a county behavioral health agency may use the form that was put out by the state, and that's strongly encouraged if possible for counties and facilities to use that form. But they may also develop their own form if they choose to. And well, again, it is encouraged that facilities use the form that has been developed by the state. County behavioral health is required to accept facility referrals, regardless of what form it is on, and regardless in what manner that referral was received. If a facility or the county behavioral health agency develops their own form, there's some minimum information that should be included on the form if that information is available. And this slide lists that information. I'm not going to go through each of the items, but generally speaking, it's information regarding the individual's identity, date of birth, some contact information, again, if available, Medi-Cal client number, if there is one, and some other identifying information of the individual that is being referred. Additionally, the form should include information about the behavioral health professional who is making the referral and the facility in which they work, as well as the date of the referral and some basic information. The facility should include any information that they believe will help in a successful transition of the individual through the care referral process. They may include the reason for the hospitalization, client-specific needs, again, any information that will help county behavioral health in assessing the individual's eligibility for care. They also need for a licensed behavioral health professional or their designee to sign the referral form. That licensed behavioral health professional must have had knowledge of the individual's case, have been involved in the individual's treatment during the involuntary hold, and believe that the individual is likely to meet the care eligibility criteria. And again, that licensed behavioral health professional or their designee must sign the referral form. So now we're going to go back to our training session. Information sharing around referrals in general, and facility referrals in particular, a lot of discussion since CARE came into effect around information sharing. Obviously, the medical and mental health information that's involved is very highly protected under HIPAA and state law confidentiality protections. So the facilities are going to have to think about how they can share information with behavioral health in the most effective way while still meeting the requirements of those protections and those laws. One thing that we would discuss is that with CARE's focus on collaboration and voluntary engagement and voluntary participation, it really would be ideal if the individual consented to the sharing of their information and allowing for the referral to be the referral to contain that information. So that's the ideal situation. If receiving consent from the patient is not an option, the consent isn't provided, then you should talk to your privacy officers and your legal counsel as the best way to share the information, what you can include and how it should be shared with behavioral health in making the referral. So going into the next slide, let's talk a little bit about kind of sum up some of the things that we've talked about. And I'm going to ask to bring Deborah, if I could bring you back into the conversation, to talk a little bit about what factors facilities should consider when they're deciding whether or not to make a referral under these statutory provisions.
Right. Thank you, Leila. And certainly we've been hearing through our county partners some of the factors that they've been considering in terms of referrals versus petitions. And so certainly eligibility is the first one. Does somebody meet care criteria? Are they likely to meet care criteria? The second one is would the individual likely benefit from it? Can care put together a package of services that will support the individual and the community in his or her recovery? Is care the less restrictive alternative? Or is this the intervention that would provide the most flexibility, the most opportunity, again, to be part of a treatment and recovery pathway? I would wonder if the individual open to care. Is that person engaging? Are they asking questions? Are they receptive to the idea of participating in care, in a care agreement or in a voluntary agreement? And then last, I think the big thing, which we've talked about a lot, is can a referral be an effective pathway through collaboration on care? In some cases, a petition may be more effective or more, what's the word I'm looking for? Maybe more of a direct route, depending on timing and availability of information. But in other cases, a referral to county may be the most appropriate thing. Perhaps the person is living in a county that's not neighboring, or that county of residence has more information that can support the filing of a petition. So I would be thinking about all these things as possible factors when going down a petition versus referral route.
And Deborah, I think the point that you made, the last point, is one that's really worth reiterating, is that the facilities do have an option. They can do the referral, and there's a lot of reasons, and you've explored some of them as to why that would make the most sense and be most beneficial to the individual. But they still do have the option, if they qualify under the eligible petitioner provisions, they do have the option of filing the petition directly themselves, if that makes sense. So it's not an either or, it is an either or, but there's two different options. There's not just the one.
And I'm going to go off script for a moment and mention that we have been asked, what if the county behavioral health doesn't agree with the filing of a referral? Let's say somebody makes the referral and the county thinks we don't consider this as a care respondent. But what that means is that there still is the option for the initial agency or individual to file a petition. It also may mean that if the county doesn't respond, they can think about what are some other solutions or services that can be provided to the referral source. So you're right, it doesn't have to be a one or the other, and it really is an opportunity for collaboration.
And so to continue off script for just a second, and then we will get back on script, important point is that the county is required to accept the referral. They are not required to file a petition if they do not believe the individual is likely to qualify for care. So they will use their professional judgment in making that determination as to whether to file the petition, which is an opportunity for the facility and County BH to collaborate and discuss if county does not file a petition, why didn't they file it? What was their concern about eligibility, et cetera? And that conversation would be a healthy one to have at that point if that were to happen. So we're going to move along under the topic of statutory referrals. The next set of referrals that are set forth in statute are court referrals. So this is a court to care court referral. Starting with the referrals from the LPS conservatorship court. Many of you may have already be aware of this. This has been in the statute since I believe its inception. And what this is this allows a conservatorship court to make a referral to care for consideration of whether the individual is eligible for care. Keeping in mind that care is a less restrictive option to conservatorship, so it is an option that should always be considered. And the statute actually requires the conservatorship court to consider whether care is an option or not in making its decision around conservatorship. The CARE Act provides that an LPS conservatorship court may refer an individual care. Again, the referral is made by the court, but there needs to be a petition, and that petition is to be filed by the conservator or the proposed conservator. So this is the one case where it is not County Behavioral Health that's filing the petition, but the conservator or the proposed conservator. The statute doesn't set forth a specific process or timing around these referrals. So this is one of the many instances where the courts and the county agencies really need to coordinate how these referrals are going to be processed in your county. And the courts are going to have to work with and collaborate with one another, because it is very possible that there may be a dual proceeding in the sense that the conservatorship proceeding may be continuing at this and be progressing or in process at the same time that the care referral is made and the care process is initiated. So the courts will have to collaborate on how they're going to handle that overlapping jurisdiction. It is very important to note, and we say it in many of our trainings, that while the CARE Act provides for a referral process from conservatorship court to the care court, the Act does not provide for referral from care to conservatorship. So the referral really just goes in the one direction from conservatorship down to care. The next court-to-court referral, and this is a subject that is being discussed a lot throughout many of the counties in the state as these type of referrals are starting to be made. But this is a referral for individuals who have been deemed incompetent to stand trial in a criminal case, both in either a misdemeanor or a felony matter. And the CARE statute provides that individuals who have been determined incompetent to stand trial, and you'll see the initials IST as the abbreviation, can be referred by the criminal court to the care court. Again, a lot of discussion over this because the language in the penal code sections that implemented this referral path don't necessarily cleanly line up with the language in the CARE Act itself or in the care process. So courts are going to have to work to figure out how they want to interpret those statutes, and that is the court's responsibility to interpret the statute. So there's a lot of discretion in how they're going to do it. Again, can only emphasize that communication with your courts to understand how they're going to interpret some of these statutory provisions is really, really important. So we start with the misdemeanor IS. The referral is by the court. As we've discussed, there needs to be a petition. By statute, the petitioner is to be the county behavioral health agency. And I'm going to read a section of the penal code section. I'll try to talk slowly because it's a long sentence and I tend to talk quickly. So the penal code language reads that if a hearing to determine eligibility for the care program is not held within 14 court days after the date on which the petition for the referral is filed, a defendant who is in custody in county jail shall be released pending the hearing. That penal code section has several different verbiages or mentions several different things that aren't really lined up in the CARE Act, and that opens the room for interpretation, as I've discussed, that the court will have to do. And so what we are doing through this slide is presenting one interpretation. It is not necessarily, it's clearly not the only interpretation, but one that we would put out there for you to think about and talk to your legal counsel about and perhaps your courts about. Again, the language doesn't line up clearly with the CARE Act, so we're working on trying to interpret it and put the pieces of the puzzle together. So this interpretation, the one that we've presented on the slide, is that the 14 days that's discussed by which the individual who's in custody in county jail would have to be released would start running at the time that a petition is filed in the CARE court. A petition filed in the CARE court based on a referral from the IST court. So the court would make the referral, and the county behavioral health department or agency would determine whether or not they believe the individual is eligible for care, and if they do, they would file a petition, and from that period, the 14 days would start running. Not a perfect interpretation of the statute in that still would require that the care process might have to be compressed a little bit in order to allow for the 14 days to allow for there to be a hearing on the merits before the 14 days elapses. But again, these are all factors that the court is going to have to decide how they want to interpret and how they want to work it out. So again, we put forward this possible interpretation of the statute just for food for thought. The statute does clearly provide that the misdemeanor case will be dismissed 6 months after the referral is made from the criminal court, unless the case is referred back to the criminal court before that time. So that would occur if the behavioral health agency receives a referral, does its assessment, and does not believe that the individual is likely to qualify or be eligible for the care. So they refer the referral back to the criminal court for the criminal court to proceed. Felony, yes, so individuals who are charged with a felony who have been deemed incompetent to stand trial, actually the statute provides even a little less clarity, unfortunately, but the referral is made by the court. The petitioner is not specified by statute. Most logically, it would be the county behavioral health agency. That's something that the counties will have to determine. A hearing to determine that has the same language around the requirement that the individual be dismissed from county, released from county jail if within 14 days, and there's the same ambiguity around what that 14-day period is. So that, again, that's something that the courts will have to interpret. And then the statute provides that in a felony case, the criminal charge will be dismissed if and when the individual is accepted into care. Unfortunately, the statute doesn't define what acceptance is. So a couple things to keep in mind, and again, deferring to the discretion of the court to make that decision. And different courts may interpret it differently. But I would point out the statute doesn't tie the dismissal to the completion of the care process. So it could be a question of how far into the process does the respondent need to progress before they are, quote unquote, accepted into care. Some courts may correlate acceptance to when the care court has determined the respondent is eligible for care, and that generally occurs by the time of the hearing on the merits. So again, this is a gray area. The courts are going to have to work to interpret it how they believe most appropriate in their county, but those are just some guidelines that we thought might be helpful for you to have in your head as you're working through these issues. And then the last statutory referral, and it's also a court-to-court referral, is a referral from assisted outpatient treatment to care. Assisted outpatient treatment, many of you may know, is Laura's Law. And this allows for the referral. The court makes the referral. County BH is the petitioner. And there is no designated process or timing, so this is another one of those areas where collaboration between County BH, the courts, and the other justice partners would be really important to determine how that process would work in your county. It would also be really helpful for the AOT programs and the county behavioral health programs to collaborate and coordinate on the services that are going to be offered to ensure that the respondent or the individual is receiving comprehensive services, but at the same time not duplicative services. And lastly, before we move on to the non-statutory referrals, let's talk a little bit about communication between the courts. With court-to-court referrals, it's very likely, or it will be, that there might be two court proceedings occurring at the same time. So it's important that the criminal court be talking, or the LPS court be talking to the care court. So SB 42, which we referenced before, and we referenced the brief that we prepared also, provided some, or included some provisions that were specific to allowing the courts to communicate with one another. The first is that the care court and the referring court can share case status and relevant rulings while both cases are pending. Little note, this refers to AOT referrals, LPS referrals, and missed referrals. Likely due to a oversight in the drafting of the legislation, FIST is not included in this provision. Felony incompetent to stand trial cases or referrals are not included at this moment in this provision. The statute also now allows courts handling juvenile dependency, delinquency, or transition cases. If the respondent is involved in one of those, the juvenile court may communicate with the care court on the case status and orders. And finally, the statute allows parties, so the respondent and the petitioner, to participate in the communications. However, for obvious reasons, any case disposition discussions must be held on the record in the court in which that discussion is occurring. So that's so to assure that the record is complete. So again, wrapping up the statutory referrals, let's talk a little bit about how courts and county behavioral health agencies can effectively coordinate the referrals. And I've spent a lot of my time over the last few slides talking about the necessity, especially given some of the ambiguity in the laws, for the county and the justice partners and obviously the courts to discuss how they're going to implement these referrals and how they're going to effectuate these referrals in their county. That should include looking at the roles and responsibilities, the timelines, if there's any forms that might make it more effective and more efficient. And those are all things that you can be doing or you should be doing with your courts to understand what the protocol is going to be in your county. Deborah, can you think of maybe other ways that the county BH and the courts can work together, or the county BH and its partners can work together to make these referrals more effective?
Thanks, Leila. And some of the things that we've learned are based on what's happening in the counties. We've had the opportunity to partner as liaisons to counties and in joining their meetings. And so some of the things that have been done to really effectively support that communication has been regular stakeholder meetings. And many of the counties have monthly or more frequent meetings where all of the stakeholders, the court, DA, public defender, peers, NAMI, the jail, medical providers, et cetera, and certainly County BH come together to talk about what kinds of work streams and processes they can use so that they can facilitate communication, align expectations, and put together effective protocols. I think it's been very helpful when counties have identified a single point of contact or identified people who are liaisons to the court. That really does help establish some ongoing communication, means that individuals can be kept abreast of timelines, and it just really ensures that there's no gaps in that handoff. And then I would also say what's been very effective has been when the counties and the courts share education, share resources, come together to try to work through some of the issues and challenges, and to also to celebrate some of the successes. So I think I'm going to give you a break because you've had a lot of slides, and I'm going to move on, and we'll move away from statutory referrals for a moment, and let's talk about system partners and those other referrals, which again may be an opportunity to connect individuals to care in the counties. So again, we just talked about these statutory referrals. Those are the ones that are specifically described in the care statutes. There are not others. We've talked about LPS and court to court. Those are the big ones. And so counties are not required to accept referrals from outside of those pathways, but certainly many of them are accepting community referrals. And some counties are actually choosing to accept all referrals, and when appropriate, are choosing to petition on behalf of that referral source for individuals in their community. So it varies from community to community, and I think that folks are learning as we progress. So again, nothing precludes behavioral health agencies from accepting referrals from system partners, whether it's hospitals, general hospitals, I'm talking about first responders, families, and in these instances, people come together to figure out what's the right pathway for their community. Again, one thing that, and we haven't talked about it much here, but it is always the case, is that because the County Behavioral Health Agency steps in as the petitioner early on in that process, that may be an opportunity that can support the filing of a petition, and it may be helpful to make that petition process a little bit more effective, and certainly it may help to make the outreach and engagement occur earlier on. So we encourage you within your county to look at what systems you have in place, what you might want to try, and what could be effective in your community. Last thing I'll say is that we are working again with some established organizations, jails, hospitals to do so. So lots of opportunities here to consider those elective or those non-statutory referrals coming from community organizations. Let's go to the next slide, please, and think about what are some of those considerations. Here I am encouraging you to think about it in your county. So what would that mean? What's the value to that? Certainly there are times where county behavioral health may know that familiar face, may have experience with the individual through various interventions in their community, may have access to that person's medical records or their treatment history. And so in these instances, a referral to county BH may result in more information within a petition. Certainly that may mean that it's easier to file a petition. There may be more success in passing prima facie because the county does have those records. One thing that we've heard about has been really interesting is that in some cases, families are hesitant to file a petition because they are concerned about tensions that might exist between a family member and the identified individual. Since the petitioner is named on the petition, sometimes they don't want to jeopardize the relationship that they have with the person and file a petition against, I'm making air quotes, against that individual. And so in these cases, county behavioral health agencies have often supported family members and said, we'll come in and stand in as the petitioner, really in an effort to avoid any of the tensions that might exist between family members. And so that's something to think about. Again, and I've mentioned it in a few different ways, by counties choosing to do this process, they can screen for eligibility. Again, a referral does not equal a petition. A referral to County BH means that they are going to consider eligibility and make a determination if the person meets or may meet eligibility criteria. They may choose to do outreach early so that there could be an opportunity to look at a voluntary agreement and to engage that person early on in what kinds of services and packages are put together. And again, we talked about the collaboration may mean more sharing of information. It really is also an opportunity for the county to present care early on. What does it mean and who can we involve to support you? And then last, probably not last, there are probably other benefits that I'm not thinking about, but certainly the last one I'm going to talk about is that by providing referrals or considering accepting referrals from these non-statutory entities, it may mean that counties can identify resources, treatment opportunities, recovery supports for people who don't meet care eligibility criteria. And so these folks can continue to be supported in the community with services, as maybe can a family member or others. So it doesn't mean that a care referral that doesn't have the eligibility criteria is put to the wayside. Instead, it means that that person can really still receive robust services outside of the care process. Let's go to the next slide. And before we wrap up, and I'm glad, Leela, that you are still here with me, I think that we are going to say, let's think about the existing processes and those relationships. And Leela, I'm going to punt it back to you and say, what are some of the processes and relationships that can support those non-statutory referrals?
Deborah, I think we've talked a lot about them a little bit already, so let's just kind of reiterate some of them. One of the things that I think that we have found that has been helpful in counties is that they've established like specific designated liaisons in their various partner agencies. So for instance, behavioral health would have a liaison that communicates directly with EMS or law enforcement, or the facilities. Maybe it's the same person, maybe it's different people depending upon their specialty or their expertise. But to have that designated person so that if somebody has the potential referral that they would like to make to BH, they know who to contact and they can have a conversation with that contact before they make the actual referral, so that the referral process is as smooth as possible. Leveraging communication in various venues. A lot of counties are having regular care county partner meetings as well as community meetings, using those as opportunities to share referral pathways and the processes involved and have discussions around those. It has proven to be very helpful. A lot of family members throughout the counties have asked, can they make referrals? And as Deborah's pointed out, that depends upon whether the county is in a position and has chosen to set up that pathway. But that is a pathway that seems to be in demand throughout the state. So it's one that the county should consider whether it's something that they can support in their county. And some counties are actually developing MOUs, memorandums of understandings, with their partner agencies, so that the roles and the responsibilities are really clearly set forth. Everybody knows what they're supposed to be doing, whether they're making the referral or receiving the referral, and how that collaboration is going to work in practice. And that provides some definition around the process and helps to assure that everybody is meeting the expectations that are set out for them.
So the goal of this training session is that you would have an increased ability to explain the difference between petitions and referrals, understand the different components for referrals for the care process, and identify differences in some of those referral pathways, and also that you'd better be able to describe how counties can process and respond to care referrals. We want to talk through a few different resources. So on the CARE Act Resource Center page, you'll find a number of resources to better understand care. So a few ones that I wanted to point out, and again, you can click on these in the training materials. Resources for petitioners. Also, it provides a link to training and resource libraries where you can filter by both audience and topic. You can also go to a county directory page, and this has links to all the different care websites across the 58 counties in California, as well as some links to available care court websites in each county and some information about care court days and how to file a petition. We also have some FAQs, which again, you can filter by topics. There are a number of ways to contact us. You can join our listserv where you could get updates and training notifications, and also a couple different ways to request technical assistance, and then specific to data. You can also provide stakeholder feedback, and there is no wrong door. So just email info@careact.org if there's any questions. And then I just wanted to highlight on the available trainings and resources page, we include recordings and decks of live trainings as well as asynchronous trainings on many different topics. At the top, you see of each the training and the resources page, some intro level materials for care. So this can be good to check out if you need more context related to the CARE Act process. One training we wanted to highlight in particular was about trauma-informed care. Trauma-informed care includes a set of principles that promote a culture of safety, empowerment, and well-being. We try to infuse this approach throughout our trainings and talk to many teams about how they're incorporating a trauma-informed approach throughout care. We just spoke about how to apply this concept in the realm of referrals. We have a number of trainings for both county behavioral health and other implementation partners such as courts or facilities. And we also have a series for volunteer supporters or a more lay audience. That could also be helpful for family members who are supporting someone through care. So a number of resources there. And again, if you have any questions, there really is no wrong door. If you email info@careact.org, we can try to connect you with the most helpful resources. Thanks, and let us know if you have questions.